He's in the back.
District 2,
Present.
District 3,
Present.
District 4, District 4, District 5,
Present.
District 6, present. District 7, District 7, District 8, District 9, District 9,
Be late today.
District 10,
Present.
District 11, District 12, District 12, District 13,
Present.
District 14, and Place 15.
I'm here.
Have quorum, sir.
Thank you very much. Ms. Pacino, good morning, ladies and gentlemen. Today is Thursday, November 16th, 2023, 9:35 a.m. We appreciate your patience. We had a brief committee meeting this morning. We're going to go ahead and jump into the docket, Commissioners. Items number 1 and 2 will be briefed on request. Are there any questions on those two items, or we will brief them? Any questions on items 1 or 2? Two minor amendments, Commissioners. Any questions? Commissioner Housewright, please.
On item 1, a question and observation. The area of request is noted as 17 square feet, and I assume that's 17 acres. And so that was all. Okay. Okay.
It was a typo. Sorry
Right,
about that.
right.
I did see it yesterday. I do apologize.
Well, I know Ms. Blue and Mr. Baldwin are very dedicated professionals here, but that was great. 17 square feet.
Any other questions, Commissioners? Yes. Commissioner.
Yes, is this on item 2? There's a creek that flows through that property, and I assume that's been taken into account. It won't impact any of the new development that's been requested.
I'm sorry, item 2 is for Jennifer. Is she on WebEx?
Christmas.
Yes, okay, thank you. Jennifer, we can't hear you, darling. Thank you.
You're muted.
Okay. Yes. My question was, there's a creek that flows through the middle of that property. I'm assuming that's any potential flood impact or something has been taken into account regarding the new development.
The only new development is the only new development.
They were adding a softball field and a theater addition.
Yes, none of that will impact the creek that runs through the property. If there is any that's determined at permitting, they will take care of that at that time, but none of this should impact that.
And I'm assuming there's no floodplain issue or anything related to the presence of that creek.
There is not. I believe actually the softball field has already been constructed out there, and this is correcting an existing condition. I believe that they constructed the softball field so that it doesn't actually encroach into that floodplain area.
Okay, thank you.
Yes, sir.
Thank you, Commissioner Hall. Commissioners, any other questions on items 1 or 2? Okay, we'll move on to item number 3. And Ms. Moorman, we do need to brief this item.
Okay. This is minor amendment M223-034. Maybe. I am so sorry. I'm not moving on. I apologize. What am I doing? Share screen. Okay, and then how do I get rid of that?
I'm sorry?
Why is that still up there? Okay. This item is M223-034, which is a request for a minor amendment to an existing development plan for property zoned PD 68. It's the Cooper Aerobics Center, and it encompasses 24.4 acres, and it's in Council District 11, located in the north part of Dallas. It is on the northeast corner of Preston Road and Willow Lane. Surrounding land uses are residential. And here's an aerial of the entire Cooper Center. Basically, the summary of the amendment is to add an addition to the tennis courts area to provide pickleball courts. It also involves the reconfiguration of the parking area with a net gain of 5 parking spaces. So here's the proposed plan. You can see at the top, the red circle is where the additional, the court area is going to be added. And then to the left of building number 5 is the relocation of the parking. A little bit closer. And here's an aerial with the areas actually highlighted that are being added or reconfigured. So you'll see to the plan north of the tennis courts, you've got this area that's shaded in blue with an outside green rim. That's the additional court area. And then the highlighted yellow is the relocation of the parking. This is the existing development plan that shows where the area of amendment will be. And staff recommendation is approval.
Thank you very much, Ms. Mormon. Questions, commissioners? Commissioner Carpenter.
Ms. Mormon, a sound deadening fence is being proposed for the east side of these courts. Is that because that's where the closest residential adjacency is without additional buffering by either other buildings or by extra distance?
So I believe the applicant intends to buffer with a sound wall or a sound fence on the plan north. Let me go back. Let's see. In
I believe it was to be on the east side.
this area. And this is approximately 140 feet from the property line of the single family that's to the east, which is actually looking plan north, or looking at the aerial, it's to the top.
Okay, and so for the neighborhood, the residential neighborhood to the south, there's plenty of distance, and there are intervening buildings that will provide adequate buffering.
So this area is south, and a neighborhood to the south. This is the area to the east that is the neighborhood closest to the additional sport court.
Okay, thank you.
Hi, Ms. Mormon.
Please. Commissioner Treadway.
So you and I have had a couple chats about this one. Are you aware that the city of Dallas erroneously gave them a permit to start constructing the pickleball courts?
You said that, am I aware that the city of Dallas what?
Gave them a permit to start constructing the pickleball courts a couple months ago?
Yes, I did hear that.
Okay, and are you aware that that permit should not have been issued because they had not come back before CPC?
I mean, that's handled at Development Services.
Okay.
And in their department.
Okay, so yes, and again, you and I have had discussions about this, and Cooper Clinic was in front of this body in December for an amendment to the PD that did not relate to this, correct?
That what?
That did not relate to this current request?
Correct.
Okay. And so the current request is not to change any of the permitted uses under the PD, is that correct?
Correct.
So the reason that it is a minor amendment under the PD rules is because they are essentially reconfiguring the parking.
Yes.
Okay, because pickleball's courts are already included under the game court use, which is already a permitted use.
Yes.
Okay. Are you aware of any discussions with the community on this?
I have had, as I believe you did, something from the community to the east and regarding this, and I believe that there have been several that the representative and the applicants have been in communication with the neighborhood.
Have you been part of any of those conversations?
No.
Okay, then I'll save those questions for the applicant when they speak. Thank you.
Thank you, Commissioner. Commissioner Rubin?
Yeah, just a few additional questions. In your view, why does this one qualify for a minor amendment in light of the addition or change to pickleball courts in the residential adjacency?
So these are the conditions that would require that would allow a development plan to be considered for a minor amendment, as opposed to having to go through the full zoning process. And therefore, when looking at the plan, we determined that it does qualify for a minor amendment. One of those is that if the plan does not alter the basic relationship of the proposed development to the adjacent property. Another is it's considered a minor if it does not increase a height shown on the original development plan.
And Ms. Mormon, if you don't mind, I'll just stop you there.
Okay.
And if you could focus on H1A, why, in your view, does it not alter the basic relationship of the proposed development to the
Because
adjacent?
it's the extension of courts that are already there and existing and allowed. And it's just reconfiguration of a court area in addition of that court playing area.
And if they had wanted to put pickleball on the existing tennis courts without reconfiguring them, would that have required any change to the development plan or any zoning change or anything like that?
If they were not adding that court space, just restriping the tennis courts for pickleball, it would not have triggered a minor amendment to the development plan.
Okay, so pickleball was, I know we don't get that
It's-
discrete and permitted uses, but pickleball was a permitted use
Yes.
before? Okay.
It would not have triggered anything. What triggers it is the addition of the court playing area.
Okay, great. Thank you.
Well,
Thank you. Commissioner Wheeler. Commissioner Hampton, followed by Commissioner Treadway.
Thank you, Mr. Chair. Ms. Mormon, just one question on the sound wall. I see it called out, but there's no definition, there's no height, there's no description of that. Is there any additional context related to how that is meant to be integrated within the site?
I'm going to leave that to the representative to answer. It is not a requirement in the PD, therefore it's not required to be shown on there, and it is a fence, so fences are not required. They can put fences up, just as the tennis courts already have a fence.
Thank you, Ms. Mormon. Thank you, Mr. Chair.
so following up on Commissioner Rubin's questions, because you and I have gone back and forth about this a couple times, and we also worked through what are the requirements for a minor amendment. And I've pulled the PD and looked at it. And when you look at A, which is alter the basic relationship of the proposed development to the adjacent property, I mean, I went back to the purpose that was outlined in the PD. I assume you did the same thing? And the purpose is designed as a facility providing medical professional services, medical research and education and aerobics, and an aerobics activity center. And then the specific permitted uses include a game court center. And so this is the piece that permits the pickleball use in addition to the tennis court use, correct?
Yes, game court area.
Okay. And so because this entire property is the Cooper Clinic or Center, this is in staff's view was that moving or adding a pickleball court didn't alter the basic relationship of the existing development to the adjacent property.
Correct.
Okay, thank you.
Thank you. Any other questions, commissioners, on this item? Okay, thank you very much, Ms. Mormon. Move to number 4. And Ms. Blue, good morning.
I'm sorry, for some reason my laptop froze up, so I might have to reboot it. So can I request to go after item 5, so I can have time to reboot?
Can you repeat, please, Ms. Blue?
I said hold on, my laptop, okay, I think I got it working now. Okay, it froze up for a minute. Share.
Perfect, thank you.
Okay. Okay, I don't know how to minimize this. Just move it down here. There we go. Sorry about that. This is case D223-002. A request for a new development plan. Also, PD 51P-655.122 F5 also requested that a master tree replacement plan be updated and submitted. It was updated, submitted, and reviewed by staff. The property is located in Planned Development District number 655. It's in Sub-Area 5, which is the urban center. It's also considered a residential district. It's on 15.05 acres. It's in Council District 3. It's located on the southwest corner of Capella Park and Gilliton's Way. So the applicant is actually requesting for a new development, multifamily development. The proposed on the site will be 8 multifamily buildings, 47 dwelling units, and also an open space. Here's an area view of the property. As you see, everything around the property is actually within the PD. Looking east to the site, there's already existing residential subdivision that's already developed. Looking northwest, there's 2 lots that's vacant, undeveloped land, and then to the south, there's a school that's already existing. Here's also a zoning map of the property. Here's the proposed development plan showing the layout of the buildings, also the fire lane. Here's an enlargement. In the middle, you can see there's an open space. Right here's the open space, and then also there's some guest parking here, and then also fire lane. I did ask the applicant about parking for the residents that's going to live in the multifamily, and they're going to do private garages for those parking spaces. Staff recommendation approval.
Thank you very much. Questions, commissioners? Commissioner Carpenter.
Yes, I had a question about the driveway width in front of buildings 1, 2, and 3. Most of the development, it's showing 26 feet drives, and there it's showing 20 feet. And I know I've had development plans come back after they got so far into permitting, when they, the fire department came in and said, that they all need to be 26 feet because of the heights of the building. Do you know if this is already past muster, those widths of those driveways?
Yes, ma'am. I actually sent the proposed development plan to Ricky Butler. He did look at it, and with the different height of the buildings, certain buildings, I think under 36, you could have 20 feet. Anything higher than that, you need the additional 26.
All right, thank you.
Commissioner Hampton.
Thank you. I saw in the case report that engineering had reviewed this relative to traffic. Has it had its preliminary engineering review?
I think I will let our traffic engineer answer that.
Well, my question is, there's just a substantial grade differential on the site, and it's not clear how that's being accommodated, and just wanted to make sure that this was something that is already past preliminary review. I can save it for the hearing if engineering's not here. Good morning, Mr. Navarez.
Good morning, Commissioners. David Navarez, Transportation Development Services. On behalf of engineering, I can address your question.
And it was just simply asking, there's a substantial grade differential, and if it had a preliminary engineering review, and if there was any considerations on the layout as it's proposed.
Yes, ma'am. There is a significant grade. Actually, the development plan that you're looking at right now shows contour lines denoting the changes in elevation. There is a significant change, but yes, we have gone through one round of engineering reviews and provided comments to the engineer of record.
I just wanted to make sure wasn't anything we needed to be mindful of. Thank you. Thank you, Mr. Chair.
Technically, we would prefer for them to go through you first before we begin our review, but we can't turn engineer of records applications away. We will welcome them. We only warn them. We're reviewing them at their own risk of them not being approved here. So, but in this case, I confirmed we have gone through one review.
Thank you. Thank you, Mr. Navarez. Thank you, Mr. Chair.
Thank you. Commissioner Carpenter.
For Mr. Navarez, while you're there, I understood the previous answer about my question about driveway widths to be that it had been okayed by fire because these particular buildings that have a 20-foot drive in front of them were going to be 36 feet in height, no more, but the development plan doesn't say that anywhere. It gives the height for the overall development as being 4 stories and I think 55 feet. So is that something that needs to be spelled out on this plan, or am I missing something?
I do recall that being a comment, and the plans actually have changed since we reviewed them in engineering. Generally, if a building structure exceeds 30 feet in height, the minimum width must be 26 in order to accommodate emergency vehicles. I believe that the 26 driveway width on this plan is a result of their conversations with
Okay.
fire and
But
residents.
I'm seeing on building 1, 2, and 3, 20 feet. Am I not looking at that correctly, or has it
Thank
been
you.
changed?
If I may address that, there is a driveway that circulates internally on the road, and then there's a secondary access driveway in the perimeter of the street, of the development. It's my understanding that Dallas Fire and Rescue Department has approved the design showing access for emergency vehicles on one side of the building,
All
having
right.
2 access points.
Thank you, appreciate it.
I also would like to add that we usually like on the development plan if they put the standard minimum or the maximum, because what we did find when I was working over development service, that sometimes we measure from average grade, so we do not like to put the fixed height of the building on each building, because it happens that it's not really in line, and then they have to come back for a minor amendment.
Understood, thank you.
Commissioner Herbert, followed by Commissioner Hall.
Thank you. I have a few questions. The first one is, I think the setback on these are 10 feet from the street. Was that taken in consideration in residential slope and the houses that are across the street from them?
Yes, we did look at RPS, and then also there's really no minimum setback for the PD, but we did take that into consideration.
Okay, thank you. Also on the development plan, there's a driveway. There's 2 driveways, one facing an alley and the other facing homes. Was it taken in consideration that lights coming out of the egress would be facing these homes?
I think on the planning side, I did not look into that, but I'm quite sure it was considered at some point for engineering to approve the location of the drive approaches.
Thank you. And can you explain to me why the 7 guest parking spots are enough for this type of development?
Yes, sir. So when the PD was created, it took out the guest parking requirements. Usually when we look at the PD, if they call out a specific requirement for multifamily and don't add the guest parking, the PD controls. So there's really no guest parking that's required for this development. So the applicant did go in and decide to add a few guest parkings to accommodate any overflow of traffic or parking.
So although the PD didn't call for it, and the city's parking rules don't adhere here?
Well, from my experience doing code review over at Development Service, usually if it's written in the PD, and if the PD changed the parking requirements for per bedroom, then that controls, and we don't look at guest parking.
Okay. Thank you.
Commissioner Hall.
You said that the builder plans that people are going to, the residents are going to park in their garages?
Yes, sir. So I guess on the ground level, I did not see a floor plan, but I did ask the applicant, where are you going to supply the parking for the guests? And they said they're going to do private garages for each townhouse
Is there,
or multifamily.
would the owners, the residents be allowed to park anywhere on the streets?
I do not have the answer to that question.
You know, my experience is they're going to fill their garages up with stuff and park on the street. But I'm just curious if, is 26 feet sufficient if they tried to park on the streets? I mean, could emergency vehicles get by if people were parked out there?
So you cannot encroach into the fire lane at all. So that answer will be no. And that will be something that HOA would have to handle during the life of the project.
Yeah. Okay, thank you.
Commissioner Herbert, please.
Looking at the development plan and talking with neighbors, something came up very interesting. The dumpsters or the way trash pickup will happen for these locations. Has that been considered at all?
As far as dumpster, we did not consider dumpster. I think they're going to do either valet or some kind of private service. So dumpsters are not shown on the property. I do not know how they're going to dispose of trash.
Thank you. Another thing for staff, do you know how close the nearest warehouse is to this location?
No, sir, I don't.
It's
Sorry.
fairly close. For full disclosure, my home is at the corner of this development, and my home will be abutting this development. And currently, I can hear the the labor and trucks from the warehouses currently. I can hear the young lady on the walkie-talkie talking to the trucks. I can see the lights from as far as where the warehouses are now. So I hope. The other thing for this location, are you aware that there's a gun range maybe 500 feet away?
Yes, sir, I was informed.
So folks, if I could just jump in real quick, this is a development plan case. Pretty much all that's under consideration with a development plan case is, does the plan meet or does it not meet code? Approvals of development plan cases are primarily ministerial in nature, meaning there's a lot less discretion on what staff can review and suggest, as well as what the commissioners can review and suggest. So any kind of comments about surrounding land uses in the area, stuff like that, that we would usually talk about with a full zoning case, doesn't really come into play with a development plan.
Thank you, sir. Any other questions, commissioners? Commissioner Blair.
Just on what Mr. Mulkey said, can I address him? Mr. Mulkey, because this is a development plan in an ministerial process, that means that basically, just because we have new commissioners who may not understand the process, that means that basically, we only have limited rights to reject. We must, is that also correct, that we must approve them as an ministerial process unless they fall into certain criteria that give us the right to reject them? Or better yet, the most that we can do is hold them, look at them again, behind the scenes, and bring them back and go through the ministerial process to get them to be developed. Is that not correct?
Thank you for turning this into a teachable moment, Commissioner Blair. I appreciate that. And I will kick it to Mr. Moore to kind of clarify that further.
Thank you, Ryan. Yes, Commissioner Blair, you are correct. If the development plan conforms with the text of the PD, it is ministerial and the body must approve it.
So just so that they understand, we don't get the right to reject, correct?
That if the development plan conforms with the text of the PD, then you must approve it. So that's the determination you must make.
Yeah, and just to clarify, this wasn't heading towards a motion of rejection. I am trying to protect the people that are going to be living here. At the end of the day, safety and security is what my goal is here, and to make it pretty. So thank you. Thank you for the education.
Thank you. Any other questions on this item, commissioners? Okay, we'll get to our zoning cases, commissioners. The zoning cases consent agenda of 5 through 9, 7 and 9 have come off consent. Vice Chair Rubin has a conflict on those two, so we will dispose of those individually. Takes us to case number 5, who we will table for the moment till Commissioner Sleeper is going to be a little bit late this morning. And we'll go to 6, and then we'll table maybe 7 or 8 and 9 until Commissioner Wheeler comes in. I'm sorry. And then we'll come back to those once we have our commissioners here. So we'll go to case number 6. Ms. Garza, good morning.
Good morning. Item number 6 is case Z223206. The request is an application for a new specific use permit for a bail bonds office located on the northeast corner of South Riverfront Boulevard and Reunion Boulevard, approximately 0.7231 acres. This is the aerial of the location. Surrounding uses, to the north is an office building, commercial parking lot or garage. Across the street on South Riverfront Boulevard to the west is a utility or government installation, office building, and then to the south it's an office building. And then within the side there is a liquor store, and where they're proposing the bail bonds office, currently it is a vacant office. The area request is currently developed with a building and is within the Mixed Master Riverfront Subarea of Plan Development District number 784, the Trinity River Corridor Special Purpose District. The applicant is proposing to operate a bail bonds office within the existing building. PD number 784 requires a specific use permit for a bail bonds office uses more than 500 feet away from a detention facility. These are some of the site photos. On the side looking east, on the side looking north, on side looking northwest, looking west, looking southwest, looking south, surrounding uses, on site looking east, looking northwest, looking north, looking northwest, looking west, looking southwest, looking south, and looking east. So these are the proposed conditions that they are proposing. So time limit, this specific use permit expires on 3 years from the passage of this ordinance. This is a site plan. And then it is within the 360 plan based on the current uses and the existing conditions on the surrounding areas from the area request. The proposed bail bonds office does not conflict with the goals set in the area plan for the Riverfront District. It is also within the Trinity River Corridor Comprehensive Land Use Study. The applicant's request is consistent with the goals and policies of the Trinity River Corridor Comprehensive Land Use Study. Staff recommends approval for a 3-year period subject to a site plan and conditions.
Thank you very much. Questions, commissioners? No questions. Thank you very much, Ms. Garza. Commissioners, we'll skip 7, 8, and 9 for the moment. We'll go to case number 10, held under advisement. Has this been briefed before?
I believe so.
It was briefed at the September meeting, but not the October meeting.
Okay. Okay. So then let's have updates. She stepped out for the moment. Yes. Okay. Then let's go to number 12. Very important person here in the back. We'll go to number 11. Yes. On which one? 11 and 12? 12. Okay.
We're doing 11
Let's
now,
go to
right?
11. Yes. Okay. So we have a conflict on 12? We have conflict on 12? Okay.
Could we get a clarification on 10? Are we skipping it, or are we just not discussing it because there's no updates?
Yes, we're just skipping it for the moment, but
Okay.
Dr. Udrea is here, so we'll go back to 10, please.
We briefed it before and I have no updates. I am so sorry.
No worries. Do we have questions on number 10? Commissioner Herbert?
No, I had a conversation with the owner. Part of the vacancy in the area was the abandoned hotel, and that's been demolished. He's a new owner to the site. He's hoping to clean up the site a little better, and I'm going to hold him to that, to a 1-year SUP. Sorry I didn't have this conversation with you, Andrea, but that's it. I need to read it.
If you have any questions, I'm here.
There you go.
Any questions, commissioners?
No questions.
Okay, so then we go to number 11. Ms. Algair. Good morning.
Good morning again. Okay, case Z223-348 is an application for an amendment to Plan Development District number 1050 on property bounded by Taft Street, North Montclair Avenue, Rainier Street, and Mary Cliff Road, approximately or just under 5.5 acres, located in District 1. Aerial and zoning and land use maps, you can see to the north, east, and south of the property is single-family uses in the Conservation District number 1, the Kings Highway Conservation District. To the west of the site, across Mary Cliff Road, there are 3 planned development districts, public school in PD 690, a single-family development in PD 796, and church and private school in PD 830. The PD was established on property that was previously R75A single-family district zoning in August 2021. Primary purpose was to allow the expansion of the existing public school with modified development standards. For example, they reduced setbacks from 25 feet to 15 feet. Although the PD was established in 2021, the school has been in operation on the site for a number of decades. Phase 1 is what was approved in 2021 when the PD was established, and construction is in progress on the site on the Phase 1 improvements at this time. The current request is for Phase 2, additional improvements, which includes classroom addition that is internal to the site. Taking you around the site, starting at Taft Street and North Montclair, we're looking west along Taft Street. You can see single family to the right and the school site to the left on the screen. Sidewalk on North Montclair is going to be upgraded to 6 foot wide with at least a 5 foot wide buffer. We've got single family across North Montclair. We're looking south. This is the existing school from North Montclair Avenue. This portion of the building is being maintained. And then we're looking north along North Montclair from Rainier Street. You can start to see the Phase 1 construction on the site. Corner of North Montclair and Rainier, this is Phase 1 construction in progress. We'll talk about this a little bit more when we get into the condition language, but here we are looking east along Rainier Street. Staff and the applicant have had discussions since the docket was posted, and we've amended the language a bit to allow this sidewalk to remain in its current location. However, when it is replaced, it will need to be upgraded to the 6 foot with a 5 foot buffer. There's a water line that's pretty close to the subject property at this location, and it would create some issues with them doing planting trees in that buffer. There's not really going to be enough space for that to be done at this time. This is single family on Rosemont that terminates at Rainier Street on the south side of the property, and then looking east along Rainier from Mary Cliff Road. This is the private school in PD 830 across from Mary Cliff Road. And then Phase 1 construction at the corner. And then looking north along Mary Cliff Road, you see the single family development in PD 796. And this public school in PD 690 across Mary Cliff Road. And then looking east along Taft Street from Mary Cliff Road, we see more single family, existing portables at that corner, and existing portion of the school building that will remain on Taft Street. And then looking east along Taft Street towards North Montclair Avenue. And then a quick word about the dumpster and the dumpster enclosure. There's some discussion in the case report about the location, the current location, and the proposed location. The applicant is requesting to retain the current location, which is currently legally encroaching into the 15-foot setback. They also would like to retain the current orientation And then they are asking to add condition language allowing the encroachment into the 15-foot setback. So just going to give you some more views of this and then talk a little bit about staff's recommendation. Across from the dumpsters, this is where you see single family, and then single family, this is actually the way that dumpsters orient currently. The green sort of storage building in the side there is going to be gone with phase 2 construction. It's what it looks like when the doors are closed, but unfortunately, sometimes they're not. Staff was expecting or anticipating, based on some ongoing discussions we've had with various ISD projects that have come through with the bond program, we were anticipating a proposal to relocate or reorient, and we requested that of the applicant. I think that commissioners, you should have received a couple of letters from the applicant outlining why they would like to keep the dumpster in its current location. Staff is requesting that it be reoriented so that it is out of the setback and not directly facing upon the single family across Taft Street. However, if the commission does decide that it can remain in its current location, staff would recommend not adding language to legalize the encroachment that is already legal due to the non-conforming nature of the enclosure. Proposed amended development plan. Some of these items, we've had some more discussions with the applicant, and the applicant has agreed, for example, to remove the detail for the pedestrian amenities. Applicant has also agreed to staff's recommended condition language for pedestrian amenities placed every 200 feet along the street frontages, except, of course, at Mary Cliff Road, there's not really, there's space constraints that won't allow those things to be placed there, so it's written into the condition language as well. Other than that, it's mostly site plan cleanup, and again, staff is recommending reorientation of the dumpster. The proposed amended landscape plan, the section that's outlined here is the only section that's being modified just to add some additional classrooms, and otherwise this is essentially the same as the existing landscape plan. The only issue that the city arborist had with the landscape plan was that they would recommend removing page 2, which goes into some discussion of tree mitigation and protection that are really better left for time of permitting. Otherwise, if there are any changes that need to be made to the development plan, we would need to make sure that those updates happen to the landscape plan as well, so the two plans coordinate. Traffic operations, the school is not currently, I don't believe the school is currently in operation. I believe they're operating at an alternate site right now. The applicant can maybe correct that during the hearing if needed. But there's no change to proposed traffic operations from what we already see here. And there is an appendix in the docket that has existing operations, but like I said, I believe that's for the alternate site. Due to the constraints of the site, there's really not room to have all queuing happen on private property. So you'll see queuing is proposed to occur on a couple of the streets. Some proposed signage. And then we get to the conditions. The open fence definition is being added. This is staff and applicant are both in agreement on this. This is the proposed yard, lot, and space change where the applicant is requesting to add dumpsters into items that can encroach into setbacks. Staff is recommending that the language remain as it was approved in 2021, given that that dumpster situation is already a non-conforming and legal situation. There's no reason to legalize it. I'm waiting to hear from the arborist on this. I believe that we can remove this language as per applicant's request, but he needed to double check some things on the landscape plan to make sure that all of these items that would screen parking are shown on the landscape plan, and I'll get with him between now and the hearing. If those items are shown, then we'll be able to go with applicant's request to remove this language about screening for parking. And then we've added the fence section. where fences can be located within a setback along the street frontage, given certain conditions, and updated traffic management language. And then on the design standards, this is a change from the docket. As I mentioned when we were looking at the photographs on Rainier Street, staff and applicant have discussed that Rainier Street sidewalk can remain in its current location, but if it is changed, it needs to be 6 feet with a minimum 5-foot wide buffer. However, the buffer width can be reduced to save existing trees. There's proposed to be several trees planted along that, and we're trying to avoid issues with an existing water line there. Pedestrian amenities in the staff report, these are shown as a boxed item. However, since the docket was posted, applicant has agreed to staff's recommended conditions for pedestrian amenities that you see here. And then staff recommendation is approval subject to a revised amended development plan, a revised amended landscape plan, an amended traffic management plan, and staff recommended revised amended conditions as briefed. Are there any questions?
We are ready for questions, Commissioners. Commissioner Chernow.
I have a question. I have a couple questions. On the recommendations for pedestrian amenities on Taft, the language says every 200 feet, but the development plan showed just one bench, trash receptacle, and bike rack kind of close to the intersection or to the corner. Is it every 200 feet or is it what? So the question is it just one on that stretch or more?
The initial proposal is what you see on the plan. I'm sorry, can we mute in the chambers? Commissioner, the initial proposal from the applicant was the 3 locations of the pedestrian amenities that you see on the plan. Staff requested additional locations, and the applicant has agreed to the condition language, which would require it every 200 feet, except along Mary Cliff. So the development plan is the outdated version. And they don't necessarily need to show the pedestrian amenities because the condition language will override the development plan.
So the applicant is agreed to Rainier as well, because there's some site constraints there. We have a 5-foot sidewalk, then we have a small planting buffer. Doesn't appear to be space for benches and bike racks.
It doesn't necessarily need to be right adjacent to the sidewalk. It just needs to be accessible from the public walk. And yes, they have agreed to place those items on all streets except for Mary Cliff.
Okay. And one last question with regards to the dumpster. Mm-hmm. I know the issue is that its corner is in the front yard setback. If that were not the case, if it were just shifted, is there anything that would mandate that they change the angle?
There's nothing that would actually mandate that they take it out of the setback at this point. It's legally in its current location. It's an existing condition. They were able to obtain permits on construction phase 1 with it in the location, so it's not actually an issue of it being in the setback. Staff's issue is that it's oriented to face single family, and we've asked them to consider other options, roll out dumpsters, whatever, to reorient it. If that's not possible, staff would recommend just leaving the language untouched and allow the existing non-conforming condition to remain without adding language related to it.
Okay. And I don't want to, if other people have questions, I do have one more question.
Please go ahead.
With the landscaping area around the dumpster, is there anything that can be added to create a better chance of success with getting the plantings that are required to not die I mean, if you look at that current area, it's all dirt, so even the grass is not growing there. And I have concerns that although they can come into compliance at the time of final inspection, having to plant things there, but what happens 2 years from then when they don't thrive and do what they're supposed to and cover the dumpster sightlines?
I would love it if our arborist could address that question for you. Is Phil here with us?
Good morning, Phil Irwin, Chief Arborist. The issue you're talking about is long-term maintenance. There are alternatives to putting some kind of alternative ground cover in that area that could tolerate the shade conditions. That's basically why it's pretty much left barren now, is because grass cannot sustain itself there, and also there's probably a lot of compaction and walking across that area. If they could provide, the landscape architect could provide some alternative ground cover that might work in that condition, that might work.
So my question was more enforcement ongoing. So say 5 years from now, the neighbors and everybody's kind of tired of looking at the dumpster and were originally promised to have some kind of screening. Is there any language, zoning language, that can be worked into the PD that says that there's an enforcement of ongoing maintenance?
We could apply, I would think, a specific enforcement on the maintenance of the landscaping for the campus. Generally, the landscaping is per plan in this situation, not specifically Article 10. So if we wanted to provide a specific language for an enhanced enforcement of the landscaping, I think that could be applied to the ordinance. I need to talk to Jennifer on that one.
Yeah, okay.
Commissioner Blair.
Mr. Irwin, while you're there, can I ask you a couple of questions? I think I remember reading that there was a concern if they remove the trash from the area, it would, and relocate it, it would damage the historical trees that are there. Is that a true statement?
Any type of construction or demolition of the area could potentially damage the trees in that location. It really comes down to how the process is done, what type of care is put in, and basically, I don't know where the root systems are in relation to the foundation on top of it. So, what type of damage might occur to it, it's hard to say until we actually got into the process. But there will be some damage to the trees. It's just trying to minimize it.
So what you're saying is that in the event that this body makes a determination that the trash whatever needs to be moved, then the process in which that would be done, not we, but the process in which that would be done would have some type of damage to the trees that are there. You can't say how much, but there would be some type of damage to those existing trees.
That would depend on the level of demolition. If they were to only remove the walls but not the foundation itself, then perhaps the root systems would not be heavily damaged by the activity. So it's a matter of relocating the containment of that dumpster. But if they left the foundation of that space and took down the walls, that would not cause severe damage to those trees.
Please don't leave, but can I ask Ms. Aguilar Alguire a question, please? Ms. Alguire, could you please help?
Yes,
I know I'm butchering it today. I apologize. Please forgive me. Could you please help us appreciate why there has been a discussion and a presentation or communication to this body as to where the placement of the dumpster and what it means to the conversation that Mr. Irwin is having with us right now?
As far as what it means to the conversation with Mr. Irwin, we had a conversation about this yesterday afternoon, similar to what you just heard. The possibility of possibly reorienting, rotating the dumpster enclosure without actually demoing anything. We've simply asked for them to explore any way to reorient so that single-family homes, not just single-family homes, but any residences surrounding the property aren't staring at a dumpster in their front yard. This is a similar request that we've had at all of these school bond projects that have come through. It's been something that we've discussed in every one of them, and so. I understand it was a point of discussion when the PD was approved in 2021. Ultimately, it was decided that it could remain in place. However, we're back here again for an additional ask for additional improvements. And we've had these ongoing discussions. So like I said, we anticipated that there would have been more thought given to how to correct a situation that we try to correct at every campus that has come through on the current bond package. If there's a way to do it without causing, damage to the trees, simply by, like Mr. Irwin said, to remove walls and reorient. Staff understands that there are constraints to this site. It's a very small site. They're stuffing a lot of stuff there. So I understand, it needs to be retained in the general area near the existing kitchen, which is not going to be relocated. We're simply asking for kind of a compromise here to where, okay, if it can't be moved, if it needs to stay where it is, can we at least rotate it so that folks don't have to stare at it from their front yard? That's essentially where we are.
And Mr. Irwin, do you, in your learned experience, can you tell us, in your opinion, is that an opportunity that exists, or does it not exist without damaging the trees? Depending upon the demolition, but changing the orientation, would that not mean you have to change the foundation? And I don't know if that's for you or if that's for Ms. Jennifer. I'm going to say Ms. Jennifer because I'm butchering the last name today. I apologize.
I think we'd probably have to talk with their architects as to how the orientation and the spacing works. Generally, I believe that there's any number of types of orientation can be done in front of the main building that could orient that, but it may affect their loading space. I think that basically they could retain the foundation where it is and take down the wall for that location and reorient the alignment of the dumpsters without affecting the trees themselves. But I would have to talk with the ISD's team to be able to determine what the space is available once they also have to account for their loading space.
Okay, thank you.
If I can just address the issue of the loading space, there's one small loading space that's required for this property per the existing conditions of the PD, and they're not impacted by, they would not be impacted by the rotation of the dumpster.
Thank you, Commissioner Treadway.
Yeah, Commissioner Blair asked most of my questions. My only question for you, Ms. Aguirre, is have there been any complaints from the neighbors, or is this purely being initiated by city staff?
I'm not aware of any of what discussions may have happened with neighbors and as far as their neighborhood meetings or anything at this particular location. This is simply something that we address at all of the school campuses as they come through. If there's an issue with dumpster orientation, if there's an issue with proximity to residences surrounding, this is something that we just regularly discuss as a need to clean up with district staff.
Thank you.
Yes, ma'am.
Commissioner Carpenter.
Following up a little bit on Commissioner Treadway's question, Ms. Agar, I don't believe you were involved in this case the last time it came through as a zoning case. Are you aware, I'll ask, that there was considerable discussion at that time about the problems that that dumpster was presenting to adjoining properties, largely because the doors were never closed? And at that time, I believe it was the principal, although I won't swear that it was someone associated with the school, swore that they would be very diligent going forward about keeping those dumpster doors closed. But in the last couple of years, I have experience of driving past that location multiple times a week. I never see them closed. It's only been in the last few weeks now that this zoning case is pending that they have been shut at all. So it has been a problem in the area. So are you aware?
You're correct. I was not the planner on that case. However, I did look at that case report, and I understand that it was quite a point of contention at that time. I wasn't necessarily aware that it came up from neighborhood complaints about the situation. I just know that it was a large part of the discussion, and it took up some space in that staff report. So as I said, now that we're back a couple of years later, I would anticipate, or I did anticipate that we would have a proposal to rectify the situation.
Please, Commissioner Carpenter.
Ms. Algar, I apologize if you explained this thoroughly, but the sound here is a little muffled and a little echoey. So I understand that you're saying that the applicant, that basically we have collapsed the boxes on pedestrian amenities. The applicant is now agreeing with the staff. Is that correct?
Yes, ma'am, that's correct.
Okay, but I do have a question just generally about the direction that these pedestrian amenity languages have been going in the last couple of cases that we've seen, is that we seem to be moving away from specific requirements per foot, number of feet, street frontages, and going to a zoned approach or area approach, and we seem to be going the opposite way here. Can you explain what the rationale is here? Is it a site-specific issue?
This was, we asked for a similar proposal from the applicant for this campus, fully expecting that there would be a grouped approach. However, the proposal that we got back was for the 3 locations around the perimeter that you see. And so when I had discussions with the DISD contact, she basically, if staff doesn't get a proposal for those types of groupings that you see, then we default to the standard language that we have. And we basically leave it up to the applicant to propose alternatives to the every 200 feet. And so since they really didn't do that this time, we've defaulted to the standard language. The applicant has agreed to it. The staff is certainly amenable to still, looking at other types of groupings if it would be more appropriate for this campus as well.
Thank you, because it seems like on some of the street frontages here, there are, obstacles that would make along the frontage locations of these amenities be a little troublesome. So thank you. May I continue?
Please.
The box that we have about the dumpsters in the setback, the language that's proposed by the applicant would actually give them permission to put other dumpsters in other setbacks. Is that correct?
Yes, that's correct.
But if the staff language is followed, the current dumpster location is still acceptable because it was permitted before. Is that correct?
It is legally existing in its current location.
Okay.
So, they have the non-conforming right to retain it in that location.
Right, but adopting the applicant's location would open up in the future further development plans that could put dumpsters anywhere, in any required setback, correct?
Yes, ma'am, that's correct.
Okay. My last questioning has to do with the screening of loading and parking. Because I remember the last time this case came forward, there were a lot of questions about the predicted future viability of screening plantings where children were being loaded, and it was pretty much agreed, my recollection is that it was decided that imposing those sorts of planter buffer strips would probably not make sense long term. So this may be a question for Mr. Irwin. where are we standing right now as to what the desirability is for these planting strips along, I guess it would specifically be on North Montclair and Taft, or whatever the other streets are. You know what they are.
I think I might need to defer to Jennifer on that initial question.
I'm not sure I'm understanding the question. There's not planting strips per se that are proposed. It's just a parkway area, but there's not necessarily going to be trees planted in those areas.
Okay, I remember now that there was a discussion about how the grass would probably not even survive. It would just be muddy messes with children, offloading off of cars or buses. So,
well, there certainly is the option to reduce the buffer. I think that the existing front is on North Montclair, and there's that widened sidewalk at that entrance that's going to remain.
Mm-hmm.
And then currently, I believe the new entrance is going to be on Rainier, I believe. And that, even if it's on Taft, those sidewalks are currently set to remain as they are. And those are all back of curve, I believe. I think we might need the applicant to address where that new entrance is going to be.
Okay, but the status right now is that box remains, that staff and applicant are in disagreement over this item. Is that correct?
Over the
off-street parking and loading. Screening, sorry, B.
Okay.
109B.
That item, I was waiting to hear from Mr. Irwin. If those landscaping items that are in the text are shown on the landscape plan, then we can go ahead and remove the language as the applicant has requested.
And following up on that, I believe the screening of off-street parking was similar to what's in city ordinance. They're pertaining to putting screening along around parking spaces. Mm-hmm. In that case, the landscape plan does propose shrubs circling the parking space, not completely enwrapping, but where parking faces the street, there are shrubs to be identified for screening purposes.
Okay, thank you.
Commissioner Hampton.
Just one point of clarification on that. If we remove the language, would the requirement still hold? Because the landscaping simply notes that the public school, open enrollment charter school, landscaping must be provided as shown on the landscape plan, but it wouldn't necessarily require the screening. Is that accurate?
Well, I would refer to the landscape plan for what is going to be looked at for inspection. So as long as it meets screening requirements, that's what we look for. Now, if we want screening per city zoning standards, then you want to maintain that language and make sure that we're deferring to the text when applying this.
The text would control over the plan.
Right.
Thank you. Thank you, Mr. Chair.
Thank you. Any other questions, Commissioners, on this item? Okay. Thank you very much, Mr. Irwin. Ms. Algeier. Commissioners, let's go ahead and have a quick briefing on case number 12. Let the record reflect that Commissioner Housewright and Commissioner Hampton both have a conflict on this item and are stepping out of the chamber. Mr. Poole, good morning.
Jason Poole, Development Services Administrator. This is case SPSD 223-002. I'll try and go through this quickly.
Mr. Poole,
Let me know if you have questions.
We can't quite hear you. It's very faint.
Is that better?
Yes, sir.
So this is an application to create a new sub-district within the McKinney Avenue sub-district. The property is zoned PD 193, which is the Oaklawn Special Purpose District, Sub-District 152. The zoning was last amended in January 2020 to increase the allowable height and floor area. There was some provisions for additional landscaping and open space, reducing the lot coverage and the required parking, off-street parking requirements. The site's approximately 3.8 acres and is within the McKinney Avenue sign district. It's currently zoned, or the current overlay is the Quadrangle sub-district, and it's on the north corner of Howell Street and Roth Street. The site, when completed, will contain over 150,000 square feet of office, 21,000 square feet of theater, restaurant, and retail uses, also an 8-story building with other structures. This is the subject site here. Again, currently overlaid by the McKinney Avenue sub-district within the Quadrangle sub-district. This district was established in 1991. Some of the purposes were to protect historical and architectural character, ensure that significant architectural features weren't obscured, make sure the signs are complementary to the district and the architectural styles, as well as the historical nature of the buildings and the trolley. It's to make sure and reduce sign clutter and attract public to goods and services while still enhancing the quality of signs in the district. It encourages artistic, creative, and innovative signs that reflect the themes. And basically, the McKinney Avenue sign district, just to kind of give an overview, contains 4 sub-districts: the peripheral, the Quadrangle, the spine, and the Maple sub-district, which was added earlier this year. Many of these provisions are going to echo what was approved for the Maple sub-district. In general, the McKinney Avenue limits size, materials, and color and locations of signs over just general zoning. Again, the intent is to create a new sub-district. It includes modifications for plastic faces, or the use of plastic faces, flat attached signs, movement control signs, monument signs, and subdivision signs. This is the location of the McKinney Avenue sub-district. And this shows some of the surrounding SPSDs in more detail, as well as some of the base zoning for signs. To the northwest, you can see business zoning. To the north and east is the McKinney Avenue. To the south, you get into Uptown. Here is the aerial map and the zoning map. Here are some of the surrounding uses, mainly office, some restaurant. To the northwest, there's multifamily, as well as to the northeast, there's a medical clinic. To the southwest, but primarily office and restaurant. Here are some of the conditions that were altered as far as all the signs. They're due to advances in lighting. They're allowing LED, which is consistent with Maple. They're also accounting for plastic faces when trim cap is not used on individual letters. As far as attached signs in general, they're allowing signs to be attached on any facade, and they increase the effective area for upper facade signs facing Howell and Ruth. Flat attached signs, they allowed more projection under the base zoning. They're allowed, or excuse me, the McKinney Avenue zoning, they're allowed an 8-inch projection, and they've increased this to 18. For detached signs, it's consistent with the Quadrangle, which is larger than the rest of the McKinney Avenue SPSD. They provide an allowance for areas of increased density, and they're providing limits to the type of detached signs allowed, which all will need to be monument. I believe they have 4 total, with no more than 2 per street frontage. With subdivision signs, these are something that modified within this district. These are allowed under base zoning for all sign districts. These are essentially very similar to what would be a district identification sign. I think some of the original intent was to steer away from district identification signs since their primary function is to regulate content, and we, due to some freedom of speech issues, we want to steer away from directly regulating content. But there are some modifications for subdivision signs, mainly that they're allowed a little more area and internal illumination and an increase in maximum height. With movement control signs, there are some, again, these are allowed under base zoning in all sign districts. They're allowing some additional height and identification message, which under base zoning is allowed with an appeal to Board of Adjustment. And they also make provisions for projecting attached movement control signs, which would be geared toward parking. Here are the site photos. This is looking at, all of these are taken from the corners. So northeast on Laclede and southeast on Ruth. This is southeast on Vine and southwest on Laclede. This is northwest on Ruth and northeast on Howell. And here are some of the signs that are currently within the district. And SSDAC and staff both recommend approval subject to conditions.
Thank you, sir. Questions, commissioners? Any questions on this item? Okay. Thank you very much, Mr. Poole. Let the record reflect that Commissioner Housewright and Commissioner Hampton are free to come back into the chamber. Commissioners, let's go back and pick up the cases that we tabled. We'll begin with case number 5. Mr. Pepe, good morning.
Good morning. One moment. Okay. Hold up. Okay, this is Z223-153. This is going to be located off Northwest Highway near the border with City of Garland. And this is an application for an MU1 mixed-use district on property zoned to CS Commercial Service District on the east line of Executive Drive, northeast of the intersection of Executive Drive and Data Drive. It's about 2.29 acres. And the purpose of the request is to allow development of the site with lodging, retail, and multifamily uses. Here's the site as it exists today. It is undeveloped. To the north, there's surface parking associated with a general merchandise or food store greater than 100,000 square feet, and the same exists to the east. To the south, there's an utility easement, and then there's an undeveloped parcel, and there's a multifamily complex to the west. So just generally, it's currently zoned that CS. It's undeveloped. It's accessed only from Executive Drive, and the applicant's proposing hotel, retail and residential uses, allowable uses within MU. MU1 would be a more appropriate zoning on the site than the existing CS, and proximity to that residential can serve as a transitional buffer between the more intense commercial to the east, to the freeway, towards the residential to the west. And here's the site. I'm actually in the adjacent parking lot to the north looking southwest at the site as it exists today, looking kind of southeast now, looking east. It's actually the other end on a different adjacent drive looking west as it exists today. There's just brush. There's the complex, apartment complex to the west on Executive Drive, looking north towards the existing large store parking lot, the old Fry's building looking north, cross surface parking lot. And then to the east, another internal drive looking, that's on the east side of the site. I thought I skipped something. Anyway, so as for the development standards, these are the current for CS, proposed for MU, and highlight any of them should anyone ask. And just generally to compare the land uses, the hotel or motel use is allowed in CS with an RAR if less than 60 rooms. It's actually reversed. It should be more than 60 rooms and less, which is similar to an MU1, where it needs an SUP if it's less than the 60 rooms. Residential, however, is not allowed in the CS, so they do need the change to allow any residential component in a proposed mixed-use project. Staff recommendation is approval.
Questions? Commissioner Treadway.
Thank you, Mr. Pepe. Are there any residential proximity slope issues with the side that's next to the multifamily?
Multifamily is going to generate a residential proximity slope that terminates after 50 feet. So it's not as restrictive as the residential proximity slope that's generated by single-family residential zoning districts. So it would terminate after 50 feet. It has a different slope than a less low slope, I guess you could say, than residential. So as long as they backload their site a little bit or any of the potential height on the site, there likely wouldn't be any issues because there's a street there. There's a 55-foot street there. So the multifamily is putting off a proximity slope, but it's going to terminate. So there's likely not any issues with that. Residential single family is significantly farther away, so there likely wouldn't be any interaction between single family RPS and this site.
Okay, did you just say that Executive is a 55 wide street?
Yes.
Okay, so that answers that question. Thank you.
Thank you, Commissioner Carpenter.
Yes, Mr. Pepe, I wanted to clarify something about height on page, let's see, 510, the chart. It says here that with the proposed MU1 zoning, with not being a mixed-use project, the height is 80 feet. The chart, the information I have shows it's 90 feet. Is that correct? The charts that I have on the heights available in the zoning districts, it's 90 feet, just base right, and then you can go to 120 feet if you have retail as a mixed-use project.
80 feet is the base height without a mixed-use project. So if we build it out as one use, that's not a mixed-use project, then the base is actually 80 feet. So a single use.
Has that changed? I mean, the charts that I have show 90 feet.
That's not the.
I mean, the zoning district standards in 51A.
Yeah, I was looking at them earlier, and that's what's there, the 80 for no mixed-use project.
Can I get a clarification from legal on that? Because the zoning district standards chart I have in 51A shows that it's a 90 feet height in MU1 zoning without being a mixed-use project.
Yeah, see, I wasn't looking at the standards chart. I was looking at the definition of the district itself, and that's where I sent you a table that says 80 without a mixed-use project. So that's the text for the MU district that says 80, but not the standards table overall.
I've got you.
Yeah.
Okay, thank you so much.
Any other questions, Commissioners, on this item? Commissioner Hausrein, please.
Mr. Pepe, just a little historical note. Are you aware that this quadrant of land was formerly an airport in northeast Dallas known as the White Rock Airport?
I'm kind of Dallas history nerd to a degree, so I am aware.
Are you? I'm impressed. Are you aware that after the airport closed, there was quite a bit of racing activity on those runways?
No, that's
Yes, there was.
that's not covered in the materials I've.
So I heard, yeah.
Any other questions, commissioners? Thank you very much, Mr. Pepe. Okay, commissioners, let's go to case number 7. Stay with Mr. Pepe and let the record reflect that Commissioner Rubin has a conflict on this case and is not in the chamber.
7. Okay, here's Z223231. It's located here, not far from Elsie Faye Higgins Street, south of 30. And so it is an application for a TH3A townhouse subdistrict on property zoned in R5A single-family subdistrict and an NC neighborhood commercial subdistrict within PD 595, South Dallas Fair Park Special Purpose District. It's about 1 acre. And purpose of the request is permit residential uses on the site. So here's the site as it exists today. It is undeveloped. And going around from the north clockwise, there's a business school at Caddy Corner from it. There's a medical clinic northeast, another medical clinic to the east. There's some small lot single family to the southeast, small retail building to the southwest, an undeveloped lot directly to the southwest. There's a church to the west and some undeveloped lots with a couple single family mixed in there to the northwest. It's a little hard to, it's real hard to see on this map, but I did try and draw a little line, but it is split zone between that NC on the south side and the R5 on the northwest side. And then across Spring Avenue to the southeast is MF2. So it's currently undeveloped, split zoned, as we said. It's all within PD 595, and those are sub-districts within it. TH3A within PD 595 follows TH3 from the base code pretty much to the T, except it requires an SUP for surface accessory remote parking for institutional uses, and an SUP for the market garden use, which is unique to the PD. So here's the site looking northwest. I understand there's been some street improvements there on Spring. I'm going to move up northeast along the Spring Avenue, then looking back south. Now we're on the northwest side of the block, looking southeast towards those small lot homes, zone MF2, and looking east towards Troy Street is the northeast adjacency, and kind of right in the middle of the block. It's very hot this day. The grass is all dead. This is Troy looking south, 3rd Street that it fronts. And that's Troy looking south at the corner of Troy and Spring Avenue. And then kind of Troy kind of jogs and continues south there. And then this is the small lot homes on Spring, looking southeast down Spring. More of that. More of that. Then this is the adjacency to the northwest. There's some undeveloped lots and a couple single-family homes mixed in, but they're pretty small lot, one after another. But I think that someone has maybe purchased a few of them, built a fence along many of these, but there are lots underneath there. And then looking north, there's a new single-family home across Brashear from this site. And that's the medical clinic I was talking about earlier. Caddy corner to the site. And no, that was the business school. This is the medical clinic across Troy. Development standards chart for the 3 districts in the mix here. NC is a creation of PD 595, so if anyone needs clarification on what it looks like, we've got it here and I'll go over it. More R5 is going to work pretty similarly to R5 in a normal part of the city, and PD 595, TH3 also works same as elsewhere in the city. And since you probably don't have NC memorized, you have the land uses here for reference, but those are allowed by right currently on the southeast half of this block. And they're zoning away from NC to the TH3, just as a reminder. And TH3, again, same as 51A in the land uses, but it has that market garden SUP potential. Staff recommendation is approval. And that's it.
Thank you very much, sir. Questions? Commissioner Wheeler.
There she is. If you're speaking, I don't hear you.
That's okay.
There you go. We got you.
I'll wait till the other commissioners ask some questions. It's okay. I'll wait till the other commissioners ask questions. Okay.
I think she was saying if anyone else has questions, y'all can go.
Did she?
I think she was saying if anyone else had questions in the chamber,
Just
to go ahead.
Okay. Commissioner Herbert, please.
Thank you. Was this area previous like commercial lots, or do you know?
There were some, this is a few years back at least, some commercial structures built on the, right along this kind of frontage here. There were some small commercial structures built along that.
Gotcha.
It was
Is
owned
there-
NC when PD 595 went in, but I think those commercial structures are probably older than that, but they're not there at this time. That commercial structure that you see to the background is off-site.
Perfect. And Commissioner Wheeler may be able to address this, but is there a neighborhood plan for this area? And if so, is that area considered in it?
Yes, in terms of area plans, the only plan here is the South Dallas Fair Park Economic Development Plan, which doesn't really offer specific land use direction for individual parcels or anything like that. It'll likely probably be evaluated at the time of Forward Dallas overall, but at this time, there's not a specific land use recommendation or anything for either of the sites.
Okay, thank you. I see there's a lot of, the Fraser Court is over there, and there's a lot of new development, so I'll be happy to hear Commissioner Wheeler's point of view. Thank you.
Thank you, sir. Commissioner Wheeler.
Are you aware, Mr. Pepe, that this is a part of the South Dallas Area Plan Task Force focus areas that will be presented with the changes to PD 595?
I am.
Okay. Also, are you aware that that's more than a medical clinic? That's at Troy. That is also a mix of businesses, and just a small part of that is a medical clinic.
Yes.
And I guess Commissioner Herbert, the rear side was residential. The front has always been commercial. But it is a part of the plan. Okay.
Is there any other question, Commissioner Wheeler?
No, pretty much is this. It's on the consent assignment. Agenda, pretty much because it's a part of what the area plan has covered for the last 3 years.
Commissioner Hampton.
Mr. Pepe, and I apologize if you covered this and I missed it in the briefing. The balance of this block, it's noted on our plan as retail and developed. Is it currently NC?
Again, hard to see on this map. Take a look here. So maybe it's better. This block is split right down the middle, like a hot dog bun. And your right side is the commercial, or your southeast side is the commercial NC side, and then the northeast is currently R5. So you're going to have 1, 2, 3, 4 small lots that remain NC. And then there's NC up across the street here, across Troy, across Spring Avenue. But NC is something that we would consider is quite compatible with residential neighborhoods. It's the intent of it. It is pretty difficult to build anything too out of scale or intense in the NC. But there's going to be those 4 lots remaining to the southwest.
Right, and then on the 4082 through 4814 on the, I'm going to say the north side, if you will, those remain R5, correct?
Yes, on the north, so it'll,
Facing towards Brashear.
yes, so there's
Okay.
4
facing towards
4 lots that are
Spring.
going to be R5 there. And the status of those, I think there's 1 home built out at the far west corner, but then 3 undeveloped ones at this time.
Thank you, Mr. Chair.
Thank you. Any other questions, commissioners, on this item? Commissioner Wheeler, please.
Mr. Pepe, are you aware that they also have a plan for the properties on Brashear where the white fence is to be a learning farm and some mixed residential?
I am not. Now I am.
And are you aware that most of this area is driven by a Chodo who has implemented and helped build out most of the community, the new community and affordable housing over the last 25 years?
I am now.
That
Thank you.
most of the new residential homes across the street from this property was built out by the same Chodo and CDC.
Understood.
Okay, thank you. Any other questions, commissioners? Thank you very much, Mr. Pepe. Commissioners, will go to case number 8. Ms. Bridges. Good morning and welcome to the Plan Commission.
And before we start the next briefing, commissioners, I just wanted to reintroduce everyone to one of our new senior planners on the zoning team, Gianna Bridges. You guys met her a little bit earlier this year, but this is her first time presenting cases to CPC, and I expect a raucous round of applause after her first presentation. It takes a lot of grit and courage to come before you guys. So yeah.
No pressure at all.
Is that a good height for you?
There's a magic button there.
This is 23-3004. The case number is Z223-232. And this is an application for R5 Single Family Subdistrict on Property Zone and NC Neighborhood Commercial Subdistrict within Planned Development District 595, the South Dallas Fair Park Special Purpose District on the southeast line of Easley and west of Bear Street. And staff recommends approval.
Gianna, could you go through the PowerPoint presentation just slide by slide, show us the site photos and whatnot? Thank you, ma'am.
Okay, it is 0.24 acres. And this is the location map. Again, it is located on the southeast line of Easley and west of Bear Street. This is the area map. Outlined in blue is the subject site. You will see surrounding the property, you do have some single-family and some undeveloped areas. And it's currently zoned NC district within PD 595. And again, it's located on the southeast line of Easley and Bear, and they propose to develop a property with a single-family residence. So that's why they're asking for the R5 single-family district. This is the subject site. They did have a notification sign. I will get to that picture in the next few slides. This is on Easley, directly across the street. This is on Easley, and I'm looking towards the 6100 block of Carlton, Garrett, and Easley, that intersection. Again, I'm on Easley, looking towards Easley and the 6200 block of Bear and the Easley intersection, and those are single-family homes. Again, I'm on Easley, looking towards the 6200 block of Bear and Easley. And this is the notification sign. I did reach out to the applicant asking them to post the sign, so they posted it and they sent me a picture. And on this slide, you will see the development standards. Ryan, do I need to go into detail about the development standards?
Yeah, if you could, Gianna, just real quickly, kind of go through some of the weird little nuances with this, block face continuity and whatnot. Thank you, ma'am.
So no front yard is required, but if they do provide a front yard, it must be a minimum of 15 feet with landscaping, so they will have to comply with Article 10. And if R5 is approved, the lots will impose a 15-foot side and rear setback on the adjacent NC lots, which is next to the particular site. It is vacant right now. If approved, R5 lots will impose a residential proximity slope on the adjacent NC lots, so that means they can't be taller than 26 feet. And if approved, the R5A lots will impose a 20-foot front yard on the adjacent neighborhood commercial lots due to block face continuity, because there will be 2 or more zoning districts on this street. And again, staff recommends approval.
Thank you very much, Mr. Jess. It just gets easier from here. Commissioners, questions? Any questions? Commissioner Housewright, please.
I'm curious, it appears that the case encompasses 2 platted lots, yet we're talking about building 1 home. Is it going to leave 1 platted lot for future development? Is that what we're?
Yeah, that might be a question for the applicant, but the rezoning, it is 2 platted lots today. They both meet the minimum lot size requirement for R5, so they could build 2 homes on both of the lots, or possibly replat them into 1 lot and then build 1 home.
Thanks for the clarification. Commissioner Blair.
You just just generated another question for me. So if they replat it so that it's 1 lot, and that means you have 2 R5s, correct?
It would be 1 lot, but the zoning tract would still be the same.
So, okay, but then on the size of the R5 requirements, aren't they different than a R75? I don't have it memorized or on the top of my head, or R10 setbacks, so in side yard, backyard, lot coverage. Would that not be different? Or so if they keep it as a R5, they would still retain the R5 setback, side yard, blah, 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 and lot coverage, correct?
Correct, yeah, whether it remained 2 lots or it was replatted into 1 lot, the same set of development standards would apply, because the full area would still be zoned R5. Thank you.
Thank you both. Any other questions? Okay, we'll stay with Ms. Bridges. We'll go to case number 9. Let the record reflect that Vice Chair Rubin has a conflict on this item and is not in the chat. Commissioner Wheeler, please. Question, Commissioner Wheeler.
I do. So, I might be a little confused because I had a community meeting. Was the applicant saying that possibly if they changed the zoning, that they were going to that they were going to put two structures? Because the community was up on the impression that they were going to put one structure.
From the conversation I had with the applicant, they only proposed one structure.
I do want to leave it on consent, but I mean, I don't, because I want to make sure, because I know that this particular street was very adamant about, because they're oversaturated with those, where there's two lots and they're building those, I guess, I would say shotgun 2 stories all over that area. And this particular street was very concerned with not having any more of those. So I don't know whether to take this off the consent or what, or talk to the planner. Okay, all right, okay.
Yes, so Commissioner Willer, it sounds like you may have questions for the applicant about their intended use of the property. So yeah, it may be good to take this case off consent, but what staff can answer for you this morning is what would be allowed under an R5A subdistrict in PD 595. And like I said, it would allow 2 dwelling units, or it could be replatted into 1 lot and then have 1 dwelling unit. But we wouldn't be aware of the particulars beyond that because this is a general zoning change.
So, but on the current plat, even though it has 2 lots on the plat, they can build 1 house, am I right, on the plat? They don't have to
No, they would need to, any kind of structure couldn't go over existing platted lot lines. So if they did want to build 1 home on the full area of this request, they would need to replat into 1 lot, or keep a home on one of the lots and the other lot is vacant, or any kind of configuration like that. But they couldn't build a structure over a platted lot line because those setbacks would come into play.
Yeah, with the setbacks into play, because the reason why I'm confused is because most of the lots in South in our area has 2 lots on it, and they're built across lot lines. All the houses in South Dallas, most of them that has these lots, mine's included, is across lot lines.
Yeah, so there may be a history of that in the area, but any new development would need to meet current code requirements, and that would not be permitted for new construction.
I'm definitely gonna have to take it off the consent because I do know that there was a concern. We were not concerned at the community meeting, but if that might be an issue, we're gonna have to take it off the consent before we can, because that was not even told to us.
Yes, ma'am.
Okay.
Thank you very much. We'll take that case off consent. The applicant is here and available for questions at the hearing. Commissioner Blair? Commissioner Blair, no question. Okay. Any other questions on this item before we go to number 9? Okay, we'll go to number 9. Stay with Ms. Bridges. And again, Commissioner Rubin has a conflict on assignment, is not in the chamber.
This is case number Z223-233. It's an application for a R5A single-family subdistrict on property zone in NC Neighborhood Commercial Subdistrict within Planned Development District number 595, the South Dallas Fair Park Special Purpose District, and it is 0.11 acres. And it is also located by my previous case. This is the location map. The area map outlined in blue is the subject site. You will see surrounding this site, you have a lot of undeveloped areas. You also have some multifamily, and you also have some single-family homes as well. It's currently zoned NC District in Tract 33 within PD 595. It's located on the north line of Wells Street and Cannon Street, and they propose to develop a property with a single-family residence, so that's why they're asking for the R5A single-family district. This is the notification sign, and that sign was placed out there when I did the site visit. Behind the city vehicle is the site as well. This is the vacant lot directly across the street. And this is the multifamily use that I just spoke about on the zoning map. And the development standards are kind of similar, but I'll go through them again. No front yard is required, but if they do decide to provide a front yard, it must be a minimum of 15 feet, and they have to provide landscaping, and they will have to comply with Article 10. And if approved, R5A lot will impose a 15-foot side and rear setback on adjacent NC lots. Also, if approved, R5A lot will impose residential proximity slope on adjacent NC lots, meaning that those lots couldn't be taller than 26 feet. And if approved, R5A lot will impose a 20-foot front yard on adjacent NC lots due to block face continuity, because there will be more than one zoning on the same street. There'll be two different zonings on the same street. And staff recommends approval.
Thank you very much. Questions? Commissioner Carpenter.
Yes, Ms. Bridges, in the report, it says that this lot is 0.11 acres. If that is correct, this lot would end up not meeting the standard for 5,000 square feet for an R5 lot. Is it still going to be a buildable site?
Give me just 1 second. Ryan, is that something that they handle during permitting? Okay.
Yeah, so 0.11 acres is about 4791.6 square feet. Excellent catch. But yeah, so any lot zoned R5A would need to meet the minimum lot size requirement of 5,000 square feet.
I think there are, I mean, this is venturing into the weeds for me, but I mean, if it was ever a legal lot in a prior building site, I don't know where. I just wanted to bring up that it wasn't 5,000 square feet, because that jumped out at me.
Yeah, thank you for pointing that out.
Commissioner Hall.
Looking at the aerial view here, it looks like is there a structure on this property right now?
No, sir, it's completely vacant.
There's a cutout for a driveway or something now?
It was. I can go back to that photo.
Yeah. So maybe whatever was there is gone now.
Right.
Oh, okay, okay. Thank you.
You're welcome.
Thank you. Any other questions? Commissioner Wheeler, please.
Yeah, I don't even know how to get the question out. I really don't know how to get it out, because these were hotels. I mean, little bitty, kind of like hotels right here. Is this lot split also?
Can you repeat that question?
Is this lot also, is this plat also has two lots on it?
No, it appears to be one lot.
Okay, no single plat. Okay, okay. By any chance, was the applicant aware that it is up under the 5,000 square feet?
I think that'll be a question for the applicant, because I didn't ask them that.
And so
I will point out to Commissioner Wheeler, and this is something I think we can discuss and consider leading up to the hearing this afternoon, but because this is in PD 595, there is an what's this one called? R3.8A single family district, where the minimum lot size is 3,800 square feet. And that would still allow a single family use. So that might be a possibility we could consider.
Because they're in proximity to the, is there any way, because they're in proximity to the housing development that's a townhome style, Is there any way that they can possibly get a townhome, one of the townhome districts that would meet that requirement?
That's also a possibility. I think that would warrant further discussion.
Because they're on the opposite side from the Easley. The Easley is on the opposite side, this part of Wells. It would actually fit more of like going into, because I'm for sure they're going to build that side. I think the community had no issue because of that. They are, how close it is to, I don't know what they call them now, but this is the Bunson neighborhood. I don't know what the new is.
Yeah, so there are TH1, TH2, and TH3 sub-districts in PD 595 that largely default to those respective townhouse districts in Chapter 51A. Those townhouse districts have an interesting density restriction that would necessitate me doing math in public, which I never do. But we can talk about that a little bit more and see if this one lot that's about, 4,700 square feet would allow a dwelling unit with that density cap.
Okay, because it would fit that because of the side, because it's on the opposite side of Carlton Garrett Way. It would fit if any new came, but if it would fit the same, kind of like what's going into I can't think of the name of it. All I know is it was used to be Turner Courts. It's my neighborhood, but I can't remember. I don't know. I can't remember the new name. But that it would fit that area where it wouldn't look different, even if the setbacks were minimum. Okay.
Right, yeah, we can consider that.
Mm-hmm.
Any other questions, commissioners? Okay, thank you very much, Ms. Bridges. I'll look forward to working with you, commissioners. Let's go to the certificate of appropriateness for signs. Any questions or requests for briefing of any of those three there, 18, 19, or 20? Okay, Mr. Poole, you're home free, sir. We'll see you at the hearing. Commissioners, it is 11:38 a.m., and that concludes the briefing of the Dallas City Plan Commission. Enjoy your lunch. We'll see you at 12:30.